Hello everyone, I'm Mustafa, an Associate Professor at Ufa University of Science and Technology, Institute of Law, and also Legal Counsel. Welcome to my channel, Mustafa Contract Law Hub, where I'm planning to tell you about everything you need to know regarding contract law, from fundamentals to advanced concepts. Whether you are a student eager to learn, or a professional sharpening your skill, or just someone interested in understanding contracts better, you've come to the right place. So let's embark on this beautiful journey together and explore the fascinating world of contract law. Today, I'm going to talk about this important concept and the contract law. I told you about the 5 requirements to form a new contract: an agreement, an intention, certainty, capacity, and consideration. One of them, as I told you, is certainty. Today, I want to tell you about the details in this regard, and when we have the uncertain terms, and if we have such terms, how we can clarify them, and also by these terms, what is the status of the contract. So simply, when we have a contract, we need to clarify every term under this contract. If we don't have a clear term, and on the other hand, the terms are not clarified, so this contract is not binding and is not valid because it must be clarified. Think about or imagine a situation: 2 businessmen, they have or try to make a new negotiation and try to make a new agreement during their business lunch, and they want to have some terms under their agreements. So if these terms, based on the requirements that I told you, the agreements, intention, capacity, and certainty consideration, are exactly in the right way, and here today I want to tell you about this certainty, and everything is clear in this way. So this oral agreement is binding contract, is binding agreements, no matter the written version, because I told you the contract is not a piece of paper, it's an agreement. And this word, based on the basic requirements, can lead to new contract and binding and valid one. Provision for clarification. So if we have a contract and everything must be clear under this contract, it's easy to get, but sometimes maybe we have some terms that they are not clear and unclear, vague terms. In this regard, maybe some contracts try to use some special mechanisms to clarify the way, to clarify the terms. For example, let me give you an example here, like bilateral investment treaties. These treaties are international agreements, and in investment world, many of the parties are using them. Under these treaties, we have special settling dispute mechanisms. So one of these special settling dispute mechanisms is arbitration, independent arbitration. If we have some terms that they make some disputes, so maybe independent arbitration can solve the situation, but based on some special ways that I'm trying to tell you today about them. The first one, terms implied by statute. When we have vague terms, under some legal systems or under the codes and special acts, we can see these special acts speak about the silence status or speak about the silent manner, or if we have some special terms that are vague in some special type of contract. So what we can do here, I'm telling you, and sometimes exactly you see the parties they don't have any agreement based on that terms or on that manner, but they can refer to the special codes and solve the situation. For example, I can tell you about the civil code of United Arab Emirates, that this code speaks about the sale contracts. Okay, the contract law under the United Arab Emirates is part of the civil code. And under this article, if the buyer or the parties, they didn't get any agreement for the price, and they didn't say anything about the price, or price is not specified under this contract, the buyer must pay reasonable price. So you see, they didn't get any agreement, but they can solve it by referring to a special code here. And this is similar to the UK. Here you see sale of goods code, and they can use it for this situation as well. And the next one, previous course of dealing. Again, if we have vague terms, we can use some course of dealing, previous one. Prior to this situation, the parties between themselves had some course of dealings, and this course of dealings mean they had some pattern of conduct and manners. If right now they have some disputes, or they have some special vague terms, they can use this previous course of dealing to interpret the situation or clarify the situation by themselves, or know if they refer to the court, or before the court there arise some disputes. The next one is reasonableness. This reasonableness is in fact a principle, and sometimes again, if we speak about vague terms, unclear agreement, so this unclear manner can be clarified by principle of reasonableness by the court. The court here assesses the situation and speak what kind of the standards can be considered as reasonable one, and the parties how they must do to be considered as reasonable one, and so on. So this is the principle of reasonableness, that the court can use it to solve and clarify the situation. The custom in some industries or some special type of contracts, maybe we have some customs and we can use them, but we must think about it. So if we have some special acts or codes or regulations, first of all, we must refer to them. And if we don't have, and still under the contract, we see vague terms, we can use these customs to solve the situation and clarify it. And officious bystander is another test that we can use it. In fact, it helps us to know what kind of terms can be implied into the contract. So the main question here, if we see some terms that these terms are clear and obviously the parties agreed upon them to use them under the contract, so here we can use these terms under the contracts. and it's easy to understand and it's necessary to use them. Removing minor uncertain terms. What does it mean? It means if sometimes we have on the one hand uncertain terms, and on the other hand these terms are not fundamental one, it means the course or the parties can remove it or can clarify it, because it's not fundamental to destroy the base of contract, and on the other hand they are unclear and must be clarified. If we can clarify it, okay, we can use the mechanisms to clarify it. But if the course can't do it, they can easily remove it because they are not fundamental. This figure, I told you about them. If we need to clarify some terms, we see these 6 circumstances or the 6 concepts to use them. Custom, the officious bystander, and removing minor uncertain terms, and also terms implied by statute, previous course of dealings, and reasonableness. So, if we have unclear terms, we can use these ways to clarify the situation and clarify the term, because on the other hand, the contract is not valid and it's not binding. We need to clear everything, because certainty is requirement for formation a new contract. And at the end, thank you so much for joining me today. It's so great to have you here, and I have many great information regarding the contracts. Please stay with me, and for today, wish you the best. Have a good day. Bye.